Officer Dagraca. Good morning, Mr. Kiley.
Good morning, Your Honors. David Keeley for the defendant, Gregory Dagraca.
I apologize. I think every time I try one or the other. So, Mr. Keeley, good morning.
Thank you, Your Honor. Your Honors, before I begin, I'd like to, if I may, correct an important typographical error in Mr. Dagraca's brief. I refer the court to page 18, the first full paragraph. I have a citation to volume 3 at pages 103, 105 to 106. That should read 105 to 108.
Thank you.
Thank you, Your Honors. Your Honors, the appeals court got this case half right. I don't think there's any serious question that when the police gave the Miranda rights to Mr. Dagraca, that they failed to give him his right against self-incrimination. The motion judge found that the rights were, the motion judge on the suppression hearing, found that those rights were fully given and that they were read to him. Well, we know from the motion hearing transcript that Officer Trudell gave those rights to Mr. Dagraca from his own memory, and that he, in fact, left out the right against self-incrimination. So the appeals court is right when they rule that there's clear error of fact and clear error of law. The more important or the more troublesome aspect of this case is whether or not the error was harmless beyond a reasonable doubt. And I submit to this court that it is not possible that that error could have been harmless beyond a reasonable doubt for two very simple reasons. The first reason is we know from the outcome of this case that the Commonwealth had what I call an uncertain quantum of proof with regards to whether or not Mr. Dagraca possessed the drugs that were found in the home. It seems, in all likelihood, these statements added to that quantum of proof. After all, the statements were from two police officers who testified at trial that the statements were that Mr. Dagraca admitted to living in or staying in the home. That's what the case was all about. I mean,
was there any other direct evidence that he was living in the premises?
Well, Your Honor,
not influential, direct. I
okay.
am living here, or another witness saying he was living with me, or...
Well, I would say that, I hate to concede anything to the Commonwealth, but there at least may have been some direct evidence. However, there was countervailing evidence with regard to the lease.
Well, pictures on the wall. There was clothing there.
Well, there was testimony from the police that his picture was on the wall in the bedroom that clearly the Commonwealth's thrust of the case was that he was occupying the bedroom on the second floor. However, Your Honor, in a closet, there are some shoes found in the closet off that bedroom and a jacket. In that jacket, there's 95 grams of cocaine. Well, we know from this verdict that Mr. Dagraca was acquitted of the drugs that were found in that jacket, in that bedroom closet.
He gave an explanation for all of the circumstantial evidence that tended to show he perhaps possessed or occupied the apartment.
Yes,
you know, he said, well, yeah, I signed the lease, but I don't intend to move in for a while because I got to fix it up and all that stuff.
Correct.
Sure, I might have stayed a couple nights, left some of my clothes there, that kind of stuff.
You want?
Once you get that kind of stuff, and this is going to be in your favor now, what I'm going to say, don't you have to weigh that in the equation on why it's not harmless error? Because he's given an adequate explanation?
Absolutely, absolutely, Your Honor. And by the way, he never said for a moment, there's no evidence that he said that he never conceded that he stayed even one or two nights.
Okay. Well,
I mean, if I may, Your Honor.
Well, there was some circumstantial stuff, the lease, other things, tying him to the apartment.
There's enough evidence.
I'm going to ask you again, and I'm going to ask the Commonwealth, as I understand it. The direct evidence, what I'm calling direct evidence, is a police officer testifies and says this is what he said. Okay? Then we have circumstantial evidence, the signing of the lease, and there were some letters.
Yes, Your
and
Honor.
then he gives an explanation to some of that,
Yes, he
And then
does.
we know, by the way, that the jury did not convict him of the cocaine in the jacket, correct?
Correct.
From which one might reasonably infer that they didn't believe that the jacket belonged to him.
Correct, Your Honor?
So I'm really trying to figure out what am I missing here? Because he testified, correct?
Yes.
And he said, I was intending to move in,
Mm-hmm.
those aren't my clothes.
He was transitioning, there is no direct evidence other than those statements. Short answer to your question, Your Honor.
All right.
Without those statements, it's all circumstantial, and not particularly compelling circumstantial evidence.
I can't remember. Was there evidence that the police had observed him over time going in and out of the house? I don't think I recall that.
Detective Coughlin, this was a 3-week investigation in May of
Right.
April of '02. She testifies at the trial that she saw him coming and going on a few occasions.
Oh, she did?
However, Your Honor, no one sees him enter the dwelling on that day. And we know that there's a key under the mat. Plenty of people have access. The landlord's going in and out of there. People who are renovating the property are going in and out of there. In fact, when the police execute the warrant, 2 people are seen leaving. They drive
Does
away.
he have to be living there in order to have constructive possession of the drugs?
I think on the facts of this case, technically, 100%, no. But I think in a practical sense, he needs to be staying in that apartment
Why?
overnight.
Don't we have cases where defendants have, I forget what they call them, but apartments where they don't live at all, but they just use them for making and distributing the drugs, and they live elsewhere precisely for the stash houses, I guess.
Right.
But precisely for this reason, they don't live there. They live with their girlfriends, or they rent them from somebody, for $20 a day or whatever.
Mm-hmm.
So why is it necessary that the defendant live there? Couldn't it be proven that he has constructive possession, even if he sleeps at night in his girlfriend's house in wherever it was, Medford or whatever?
That's true, Your Honor. But the question here is whether those statements tip the scales. I mean...
Right, but it isn't necessary that he lived there. There could be sufficient evidence that he is there sufficiently to have constructive possession, even though he isn't living there, i.e. his personal papers and photos, the fact that he had signed a lease, so if he's the lessor on the lease, that's pretty good, that he's in some type of possession of the premises.
Your Honor, again, I concede that there's enough evidence here for the Commonwealth to get over the rail, so to speak, with regard to constructive possession of the cocaine that's found on the kitchen table.
Yeah.
However, in the facts of this case, with all the number of people coming and going, if the Commonwealth wants to nail the case down, they need to place him in that, if I may, Your Honor, place him in that renovated dwelling, perhaps even the overnight before the day that the warrant was executed, which is
Officially
what the
enough.
case is about.
Well, when you say nail the case down, I take it, what you're saying is that the case against him, there may have been enough evidence against him, but it was not an overwhelming case.
Absolutely not overwhelming, and I would venture to say that the Commonwealth...
What we can't get mixed up on here, at least from your point of view, is the sufficiency of the evidence to go to the jury, of which you just conceded there is such,
Yes, Your Honor.
against the question of harmless error, whereby if you take his explanations, the jury could well have been in the room debating, well, he said this and that, well, let's convict him because he told the officer I was living there. And we know that's harmful, impermissible, as it turns out, constitutional error.
I agree, Your Honor. The case, I submit that the case was not particularly strong against Mr. Dagraca. After all, the police testified that his pictures are on the upstairs bedroom wall, and his certain bills addressed to Medford, where he testified where he was living and staying overnight. Yet they acquit of the cocaine that's found in that closet, right off that upstairs bedroom.
I know, but I take it that was because the clothing didn't fit the defendant.
Well, that certainly was the thrust of the defendant's argument. I believe he tried the coat on at the trial. We don't know really visually how that went, unlike the O.J. case, I guess. But
That's a well-known trial tactic these days,
Right.
right?
If it doesn't
If it doesn't fit,
got to acquit.
yes, I think there was some argument about that, maybe even in the
That or
closing
Anita
argument.
Taylor.
But in this case, I'd like to note for the court
Door
that
crashed
there
out.
are certain of the cases from the appeals court.
I suppose another way of looking at that is to say, if he is living there, was there any suggestion that anybody else was living there?
Absolutely, Your
The
Honor.
tenants?
The police testified that someone was either living or staying in like in the first floor living room or using it daily, but there's no evidence whatsoever that that person was Mr. Dagraca.
Was somebody else doing renovations at the same
The
time?
landlord was doing renovations with his friends.
And the apartment had been gutted?
Virtually gutted. The first floor was gutted, except for, I believe, the kitchen. The first floor bathroom had, I think, a toilet, a working toilet, and a sink in it.
So how many workers were in that apartment?
That's unknown. We know that that the owner was coming and going, and various people. There might be a fair reference that there was electricians. Walls are torn apart. There's going to be some plumbers in there. I note that there was a key underneath the front door mat, which the owner of the property testified that many people were aware that that key was there. So there were people constantly coming and going in the case from the house. So I don't know that I don't know how these two statements, once they were admitted, could be harmless beyond a reasonable doubt. They added to the Commonwealth's case in a very, very direct way, and they were exploited in the closing argument at various points. The thrust of the first half of the Commonwealth's closing argument was that the defendant was living in the home. And at Volume 3, page 108, the prosecutor says, how do we know he's living there? Because he told us. Because he told the police. There are two specific references to those statements on page 108, Volume 3. So we know that this error could not have been harmless beyond a reasonable doubt. Furthermore, on the penultimate issue in the case, constructive possession, as I've said, the home was under renovation. Many people were coming and going. The owner testified that a man known to him had been living there the month before. And there was some question if that man, I think his name was Joseph Scimitar. There was no evidence that he had completely departed the premises. Other inhabitants' belongings were everywhere inside this home. A defendant testified that he's living in Medford. That testimony is deserving of some weight. There's a cell phone and a pager found in the home, and the police don't know who it belongs to. The defendant testifies that it does not belong to him. There is no evidence that it belongs to him. And he also testified at the trial that he did not enter the home on that day before the police served the warrant. So I would say, taking all things into consideration, but most particularly the specific reference in closing argument to the statements. I think Justice Cass in Carmel versus Copeland put the problem very well when he said that the prosecutor rubbed the statements into the ears of the jury. This jury was left with testimony that the defendant was living in the property, staying there overnight. It cut the heart out of the defense. For that reason, Your Honors, I would submit to the case that the error could not have been harmless beyond a reasonable doubt, and I would ask this Court to reverse Mr. Dagraca's convictions.
Thank you, Mr. Keeley.
Thank you, Your Honor.
Ms. Pappas?
May it please the Court, Marion Pappas, Assistant District Attorney for Middlesex, with Assistant District Attorney Loretta Smith seated at the table. The motion judge properly denied the defendant's motion to suppress the statements because the Commonwealth proved beyond a reasonable doubt that the defendant was correctly advised of his Miranda warnings and that his waiver of Miranda rights was voluntary, knowing, and intelligent. The statements that came out at the motion to suppress were that he rented it being the house at 50 Hawthorne Street, from Joe Ignaktowicz, the landlord owner of the house. Sergeant Trudell testified at the motion to suppress and stated that he gave the defendant his Miranda rights, and he asked the defendant if he understood them, and he said yes. And subsequently, the prosecutor asked him to recite the Miranda warnings on the witness stand, and in doing so, Sergeant Trudell left out the defendant's Fifth Amendment right against self-incrimination, and the Commonwealth acknowledges that. However, subsequently, Detective Coughlin testified that she was present when Sergeant Trudell gave the defendant the Miranda warnings, and that he did give the defendant a complete set of Miranda warnings.
What was her testimony exactly? What was her testimony exactly?
Her testimony was that she arrived at the house when there was a struggle going on the porch between the defendant and Sergeant Trudell, and she arrived with a search warrant in possession, that the defendant was given his Miranda rights prior to questioning, and that she was present, and that the Sergeant Trudell had, in fact, given a complete set to the defendant.
So she testified he'd given a complete set.
That is correct.
That
the
is
motion
her
suppressed.
So is it up to us to decide which police officer to give credit to?
Your Honor, in this case, it was the motion judges. The motion judge found that the testimonies of the police officers were more credible than the defendant's testimony. And he likely based his finding on the fact that Sergeant Trudell is a 16-year veteran police officer.
I'm afraid that doesn't help me, because one of the problems, and if you're doing it for 16 years, one might say, well, then he should be able to just recite it off pat like that on the witness stand. I'm not faulting the officer, but the fact that he's got 16 years of experience doesn't help me one way or the other on this issue, right?
Well, go ahead. See, the problem you got, it seems to me, is if the judge had found that he had received all the warnings because the other person, police officer, I guess, said, yes, he gave all the warnings, you'd be okay. But as I read the appeals court opinion, the judge actually went beyond that and said, here's what the warnings were that were given, and repeated the officer's testimony that left out the warning we're talking about. So what can you do about that? The judge says he gave the wrong warnings, or warnings that were not complete.
Your Honor, and the only thing I can really say that it was likely an oversight, because he...
Was there a request for clarification?
There was not, and that really should have been what happened. I mean, that really should have happened in this case. I think instead, on the day of trial, going back a little bit, at the motion suppress, it was either not picked up on by either party that Sergeant Trudell had incorrectly recited the Miranda warnings on the witness stand. It was either not picked up or it could have been tactical on part of the defense counsel. However, on the first day of trial, defense counsel had asked for a voir dire on the motion, on defendant's motion to suppress his statements, and he pointed out to Judge Fabricant what the judge had found, that the judge, in stating that the defendant had been given a complete set of Miranda warnings, that the judge had in fact left out one of the warnings. And the judge at that point said, I understand what you're saying, however, the judge found the testimonies more credible and found...
Yeah, but the problem with the credibility issue is that the issue of credibility was, did he get warnings versus did he get no warnings? The dispute wasn't, did he get the warning about whether or not anything he could say would be used against him. So the judge believed the police officer, and the police officer's testimony was defective,
Well,
in a technical sense.
I'm actually looking at the judge's ruling. Now, the judge says, I find beyond a reasonable doubt that Officer Trudell correctly advised the defendant of his rights to remain silent, to have counsel present, and to have counsel appointed if he was an indigent. I mean, I can't do anything else. I can't fill in the missing finding, can I?
But
in other words, this is not an appeals court characterization. I'm just looking at the trial judge in the trial court's conclusion.
Which the appeals court quotes. So you're stuck.
I do, Your Honor, I do believe that this was an oversight because the judge found that the waiver was voluntary, knowing, and intelligent. In all the cases, including the case of Adams.
We have a police officer who has an oversight. We have a judge who has an oversight. We have a jury which is not 100%, finding not 100% in favor of the defendant. And I think that what we have is defense counsel saying, I'm not contesting the sufficiency of the evidence.
I think it is important to note that the defendant's affidavit attached to the original motion suppress that was filed states that he was placed on the couch and that he was not informed of his right to remain silent or his right to counsel. And then at the motion to suppress, the defendant testified that no Miranda warnings were given to him. And once again at trial, the defendant testified that actually the Miranda warnings were given to him, but they were given to him after the start of questioning, and when they were given an incomplete set, and I think he stated he was only read one thing.
I'm not contesting, and I don't think can contest, the trial judge's, the motion to suppress judge's conclusion that he finds the Commonwealth's, the police officer's versions more credible. Mm-hmm. Good, lots of evidence to support that conclusion.
And Based on the fact that Detective Coughlin, Your Honor, did state that the defendant was given a complete set of Miranda warnings, that is what the judge did credit in finding that the waiver...
If he had stopped there, he would have been fine. But he then went on to state the warnings that were given.
Which is consistent with the police officer's testimony. So we're sort of stuck here, unless we conclude that everybody made a big mistake.
Why don't you argue why this was harmless beyond a reasonable doubt? Is there any other direct evidence that the defendant was of the defendant's presence in the house?
Yes, and the statements, even if it were error to admit these statements, as the appeals court correctly found, the error was harmless beyond a reasonable doubt. And the direct evidence is the lease. The lease...
Well, that's not direct evidence, because many people sign a lease. You try and rent an apartment in Boston other than the 1st of September, and even if you roll up with your U-Haul, you may take occupancy on the 6th of September, because that's when school starts. That's not evidence of being present. You can infer, but it's not direct evidence that he was actually living there.
Your Honor, there was other evidence that on the day the police attempted to execute the search warrant, that there was a struggle on the porch, and the defendant was trying to run inside the house. And I believe that is direct evidence that he lived in the house, because why else would he be trying to run inside the house? Furthermore, the defendant had...
He never said he had never been to the premises. As I understand it, what we have here is a little unusual. We have a defendant testifying, and he says, I was in the process of moving in. Some of my stuff was there. There were bills and things which were sent to the address where I was living at the time, but I had begun to move in. This, again, is not an unusual set of circumstance, and he might have been there that day, and to avoid arrest, if that's what he was doing, he would have gone presumably to the place. I mean, nobody's contesting that he had a right of access to the place.
Your Honor, but he did admit that he had moved two boxes in a bag to the first floor of the house. The first floor of the house is where all the cocaine was, on top of the kitchen table in plain view. Also, there were several of his items found in the bedroom. There were bills that had his name on them. He did not deny that they were his. They had the address in Medford, which is not unheard of, given that unless you notify the post office, how would the post office know to change the address?
No, that is consistent with his testimony,
yes.
Which is, I was transitioning in, and I had moved a couple of boxes, and I'd moved some things.
Your Honor, but there was also at least one bill that was not due until, I think, May 4th, the first week in May. Why else would he have moved one of his bills that was due in May, about a week later, to the house where he was not yet living? It just does not make sense. And it does not make sense that he had pictures of himself on the wall, that in that same bedroom there was a bed and a desk, that there was a functioning toilet and a sink on the first floor of the house. The kitchen had been totally renovated.
I thought there was evidence that the stove wasn't hooked up.
I'm not sure about the stove, but I know that there was a refrigerator working in the house.
No, but I thought his testimony was the stove was not hooked up.
Your Honor, I'm unaware of that testimony.
Okay.
However, there was a bed and a desk in the bedroom, as well as a toilet in the house, and there were pictures of him on the wall, as well as 2 notebooks. One of the notebooks had address book for Gregory, and male clothing and shoes in the closet.
And the jury concluded, the jury found, we can infer that the clothing, at least one item of clothing, the one that had a significant amount of cocaine, didn't belong to him.
Yes, which is, I can't explain that other than to say that he did try on the coat in an attempt to show that it did not belong to him. However, and that's the reason why that even if it were error to admit these statements, it did not strike to the heart of the case. Because if it did, then surely the jury would have found him guilty of the items found in the bedroom.
Not necessarily at all. I mean, the jury could have well have found that someone else had access, and that was someone else's coat, and they couldn't impute knowledge and control to the defendant. But on the other hand, the defendant admitted he lived in the house, and this cocaine was right on the kitchen table. So, I mean, that's obviously the jury could have thought that way. It's not irrational, not illogical.
Do you agree with your brother that the Commonwealth did make use of his statement in final argument? Did point that out to the jury?
Yes, but the reference was just twice on one page of the Commonwealth's closing. I think the defendant had, defense counsel had, appellant's counsel had mentioned several times various pages of closing was really
No,
too.
I don't think so.
Your Honor-
Is that page 108
Okay.
where the
Correct.
prosecutor,
Where it says, "How
the
do we
prosecutor
know?"
makes
Yes.
the point
He
twice?
told us.
However, the bulk of the Commonwealth's argument, Your Honor, dealt with all the other evidence that showed that he lived there, the lease, defendant's
Yes, but if
testimony.
you say, I've got a lease, I've got this, and how do we know that he lived there? He told us. I mean, you need only say it once. It depends how, I've got the lease, I've got the bills, I've got clothing, I've got pictures, and how do we know he lived there? He told us.
Your Honor, I believe it did not create a substantial risk of a miscarriage of justice.
No, we're
And
under
it-
harmless beyond a reasonable doubt. We're under harmless beyond a reasonable doubt, not a substantial risk.
But by the prosecutor's fleeting reference to the statements in closing is what I was referring to. Your Honor, however, the bulk of the closing did deal with the other evidence that he was living there, the circumstantial evidence, the bills, the notebooks. Furthermore, any error that might have been caused by this fleeting reference to the statements in his closing was mitigated by the fact that the judge gave the jury humane practice instruction, advising them not to consider the statements unless find defendant's statements to be voluntary and freely given. So that certainly would have mitigated any error that might have been caused by this fleeting reference to his statements. If there are no further questions, I will rest on my brief.
Thank you, Ms.
Thank you.
Coppins.